All right, if you're gearing up for the UPSC exams, you know that Indian polity is more than just memorizing articles. It's about understanding the why behind the system. Today, we're going to break down a topic that often trips people up: courts versus tribunals. I mean, they both deliver justice, right? But they're fundamentally different. So, why does India even have this parallel system? Let's dive in and get this cleared up.
Okay, here's our game plan for today. We'll kick things off by looking at why our justice system was so strained that we even needed an alternative. Then we'll see how tribunals stepped in as the solution. After that, we'll do a head-to-head comparison, trace their constitutional history, and finally, unpack the two main types of tribunals you absolutely need to know. So first things first. To really get why tribunals even exist, we've got to understand the problem they were designed to solve. And that problem begins with the incredible, almost crushing pressure on India's traditional court system. Just look at that number, 4.5 crore. That isn't just a statistic, that's a mountain of pending cases, a backlog that was piling up in Indian courts around late 2021. This one number tells you almost everything you need to know about a system under serious strain.
Think about it for a second. We've got over 1.3 billion people in this country, and they're being served by only about 12,000 courts. The math alone is staggering. It points to a system that's just fundamentally overburdened. But what does that overload actually mean for a regular person trying to get justice?
Well, this overload creates three huge roadblocks. First up, time. Cases can get stuck in the system for years, even decades. Second, the cost. Legal battles can become so expensive that they're simply out of reach for many people. And third, and this is a big one, expertise. Our judges are brilliant legal minds, but what about a case involving complex telecom regulations or environmental science? That requires a very different kind of specialized knowledge. So, to tackle these exact challenges, the issues of speed, cost, and specialization, a new pathway to justice was created. And that path was the tribunal. They were specifically designed to be a specialized, more efficient alternative running alongside our traditional courts. Now, here's a key term you'll see everywhere: quasi-judicial body. Quasi basically means partly or sort of. So they're not full-blown courts, but they have court-like powers. The real magic, though, is that they operate on the principles of natural justice. This just means they're focused on fairness, making sure both sides get a fair hearing, avoiding bias, instead of getting bogged down by the super rigid, complex procedures of a traditional court. It's a much more flexible approach. So how different are they really? Well, let's put them side by side. This is where you'll really see the unique role that tribunals play in our legal system. This table really gets to the heart of it. There are two game-changing differences here. First, who's in the room? Courts are staffed exclusively by judges, legal professionals. Tribunals, on the other hand, have a mix. You get a judicial member sitting right next to a technical expert from a specific field. Second, what's the rulebook? Courts are bound by strict procedural laws. Tribunals? They're guided by those flexible principles of natural justice, which lets them prioritize getting to a fair outcome over ticking procedural boxes. And this is really their secret sauce, the expert advantage. Think about it. The National Green Tribunal can have an actual environmental scientist on the bench, someone who brings years of real-world, on-the-ground experience that a judge, no matter how brilliant they are in law, just wouldn't have. This combination of legal and technical minds leads to decisions that are so much more informed and practical. But here's a fascinating bit of history for you. This whole system of tribunals, it wasn't actually in the original blueprint for India's legal framework. So how did they get there? Their constitutional journey is a really interesting story and a critical one for any UPSC aspirant to know. It's kind of surprising, right? When the Constitution of India was adopted back in 1950, there was no mention of tribunals at all. They're an addition, a constitutional evolution that was born out of necessity as the country grew and faced more complex challenges. So, how did we get from zero to here? It all happened in three key steps. The whole idea was sparked in 1976 by the Swaran Singh Committee. That recommendation was then cemented into our Constitution through the famous 42nd Amendment, which added two brand new articles, 323A and 323B. And finally, the idea became a reality in 1985 when Parliament passed the Administrative Tribunals Act, actually bringing these new constitutional powers to life. Now, those two new articles, 323A and 323B, they are not the same. They created the foundation for two very distinct categories of tribunals.
And for your exams, knowing the difference between them is absolutely non-negotiable. Okay, here's the simplest way to think about it. Article 323A is laser-focused. It deals only with administrative matters, basically service-related issues for government employees. And only Parliament can create these tribunals. Article 323B, on the other hand, is like a big, wide umbrella. It covers a whole range of other subjects, from taxation and labor to land reforms, and crucially, both Parliament and the state legislatures can set these up.
And the perfect real-world example of Article 323A in action is that Administrative Tribunals Act of 1985 we just talked about. This is the law that gave us the famous Central Administrative Tribunal, or CAT, at the central level, and also allowed for the creation of state administrative tribunals, or SATs, to handle all those service-related disputes for government employees.
So this all brings us to the big million-dollar question that experts are still debating today. Tribunals were created as a solution, right? A way to ease the burden on our overburdened courts. But have they truly solved the problem? Or have they, in some ways, just created a parallel track with its own set of delays and challenges? It's a critical question that really gets to the very heart of what effective and efficient justice looks like in modern India.